SJC-11418, American International Insurance Company, v. Zabicki Import Company, Inc., and another.
Yes, counsel. Good morning.
Good morning, Your Honors. May it please the Court, Trish Antasana from Reed Smith, here on behalf of the defendant appellant Robert Seuffer, GMBH. Robert Seuffer is appealing the trial court's order denying its motion for summary judgment for lack of personal jurisdiction. The trial court actually found that it indeed lacked personal jurisdiction over Seuffer, but that Seuffer had waived its challenge to the defense to personal jurisdiction. Nothing in the rules and nothing in directly controlling Massachusetts case law supports the trial court's decision.
Why did Seuffer wait?
Well, Seuffer waited because the inquiry into personal jurisdiction is a fact-intensive inquiry. Of
But
course,
that wasn't
Seuffer
what the
knows its
discovery was about.
I'm sorry?
That wasn't, first of all, Seuffer's got the information itself, whether it does or doesn't have context. But second of all, that's not what they were conducting discovery about.
Your Honor, in every deposition that Seuffer took or was involved with in this case, it inquired as to whether the deponent was aware of any contacts at all that Seuffer had with the Commonwealth of Massachusetts. The stream of commerce analysis, the stream of commerce plus analysis requires this type of fact-intensive inquiry. Is there some sort of tributary where the stream of commerce could bring Seuffer's products into the Commonwealth of Massachusetts? Does the plaintiff have any evidence to this effect? Does the co-defendant, Zabicki Import Company, have any evidence to this support? When Seuffer deposed the co-defendant, Zabicki Import Company, it specifically asked it if Robert Seuffer directed it or asked it to send its products anywhere, specifically in the United States. It did not. Robert Seuffer has only been involved with the state of Wisconsin in the United States. Nothing in the rules required Seuffer to do more than answer in its first defensive move in this case, which it did, that the court lacked personal jurisdiction, and then to reassert this defense prior to a judgment being entered in this case. In the Ingersoll case, the court found waiver only where the defendant made a general appearance and then waited until after a judgment was made against the defendant before reasserting the defense. The same can be said of the Sarin versus Oaksner case from the Massachusetts Appeals Court, and also the Vangel versus Martin case. In both of those cases, both regarding lack of personal jurisdiction, the court found waiver only where the defendant asserted the defense and then failed to reassert it until a judgment had been entered against it.
You don't disagree, A, that the appeals court cases that you are referring to certainly talk in language that it can be waived or forfeited by conduct. B, there is a great deal of federal law suggesting that conduct that does not, that is inconsistent with asserting a lack of personal jurisdiction can be used as a sign of waiver or forfeiture quite before the judgment or the trial, right?
Seuffer does not disagree that waiver can be found in certain circumstances. In this case, however, Seuffer did not waive the defense under the directly controlling Massachusetts state court case law and also the Cepeda court. The Cepeda court specifically recognized that a final determination of personal jurisdiction issues may be made at trial on the merits. And in the LaMarche case, the Massachusetts Appeals Court also explained that even if a defendant proceeds to trial, if it did not waive the defense, it retains the right to assert that personal jurisdiction defense even if it goes to trial. In this case, Seuffer did exactly as Rule 12 expects it to do, and then it reasserted the defense as soon as it came before the court on its motion for summary judgment.
Now, the other way of doing this would have been to bring a motion to dismiss for lack of jurisdiction over the person. You generally, if you say there's no jurisdiction, are in control of the facts about what contacts you've had with the jurisdiction. And you could submit that, and that would draw out any opposing facts that there might be. that's generally the way you would challenge a lack of jurisdiction over the person if you don't want to engage in litigation and spend the money that goes along with extensive discovery. I mean, you need not do it by a motion for summary judgment the way it was done here. It could be done in a much more inexpensive, expeditious way, and then you could be out.
And Seuffer certainly recognizes that a Rule 12 motion to dismiss could have been one way to go about doing this, but Rule 12 does not require it to do so. And Seuffer felt it necessary to inquire into this fact-intensive determination of how many of its products have been coming into the state, what was the case with Ziebicki Import Company, is there any other evidence out there? If Seuffer would have brought a motion to dismiss, as you suggest, of course, this discovery would have occurred, but as it stands now...
Maybe yes, maybe no. Maybe there would have been no opposing factors, because the judge here on summary judgment couldn't make, a factual determination, presumably, just that on the facts taken in light, most favorable to the non-moving party, I think the judge basically was saying you would win, right? Because there really weren't any contested facts as to personal jurisdiction.
That is correct, Your Honor, and it is unknown...
That would have been true at a Rule 12b, 12b2.
And that is true, and what would have happened under a Rule 12 motion and what discovery would have occurred,
Well, then
nobody
you
can
could have
know.
done nothing. They're not mutually exclusive things. You could do 12b2, not prevail, because there's something in dispute, and then need to do the discovery. But I'm not sure it would be in advance of a summary judgment motion. Then that would be for trial, because there'd be things in dispute.
And as you state, that is something that Seuffer could have done, but it is certainly not required to do that under the rules and under the directly controlling case law in Massachusetts. Also, the trial court cited two specific cases dealing with the waiver of the defense of insufficient service of process and the due process considerations and the constitutional minimum contacts inquiry makes the lack of personal jurisdiction defense completely different
They're not
from the
completely
defense of
different, you have
insufficient
to
service
admit,
of
because they're
process.
both waivable.
I'm sorry?
They're both treated exactly in the same paragraph. They're both waivable. They're not completely different. I agree, there are some differences, but they're not.
They are certainly both.
Personal jurisdiction is not subject matter jurisdiction. It is waivable. It is forfeitable.
It is certainly waivable and certainly forfeitable, but in this case, Seuffer complied with the rules and the constitutional considerations, as explained by the Datzkow court, which we have cited to, make a distinction between those two defenses, saying that there are due process requirements, there's a minimum contacts analysis. Did the defendant reasonably anticipate being hailed into court? Insufficient service of process, I mail you the complaint, I mail you the summons, I can fix that at the beginning of the case. There are no constitutional due process concerns with the defendant's expectations of being hailed into court in a foreign jurisdiction.
This defendant did bring a claim against another party. Right?
Yes, and in that claim, it incorporated by reference all of its answer and all of its affirmative defenses.
But it is suggesting that it is using the Massachusetts courts to assert a claim against another party, correct?
Robert Seuffer was defending its rights and simply asserting its rights as it was required to do under the rules.
Do you have a counterclaim or a cross-claim, or both?
Ziebicki asserted a cross-claim against Robert Seuffer, and Robert Seuffer returned the favor.
With a cross-claim?
Correct.
Okay, and the cross-claim would go if you win here, correct?
Correct. And in that cross-claim, Seuffer incorporated its defense of lack of personal jurisdiction.
And if you had a counterclaim, would it be different?
I have not looked into the case law in that regard. I don't know if
There's
it's
no
any different.
counterclaim that you've brought here?
No. And just by way of brief background, this is an American International Insurance Company insured a painting that fell from the wall of its insured. David Kroll, Mr. Kroll, had placed the painting up on the wall, had been there for 8 to 10 years with 2 Floriat picture hangers that the plaintiff alleges were defective.
So is this just a matter of degree? In other words, if the substantive discovery had gone on for 3 years, and then because you had raised it in your answer, you then raised it at trial, that would be okay?
Based on controlling Massachusetts authority, yes, that would be okay. As long, no judgment.
The only way to forfeit this is to simply not raise it in your first pleading, is that right? Is that the only way to forfeit?
And then appear before the court and not raise it again. In this case, Seuffer's first appearance before the court was in its motion for summary judgment. That was its first opportunity. If Seuffer had waited until after a judgment, gambled on a verdict, and then reasserted the defense, it would have waived the defense.
Thank you, counsel.
Thank you.
Good morning, Mr. Chief Justice. May it please the court. My name is John O'Brien, here today on behalf of the appellee, American International Insurance Company. For purposes of my argument, I'll refer to American International Insurance Company as the plaintiff and Robert Seuffer as the defendant. The defendant in this case is a foreign company that chose to retain counsel and appear in the Massachusetts courts.
Because it got sued in the Massachusetts courts. And there's always been a procedure for somebody who gets sued in the Massachusetts courts to appear specially, which is what they did here.
They did file a pleading that purported to appear specially, and that goes to one of the first questions that I was going to raise in my argument, which is, could a technical waiver be found? There is at least no controlling decision from this court as to whether the distinction between special appearances and general appearances has been abolished.
It has in the federal court?
It has, at least by case law in the federal court. I'm not aware of a controlling U.S. Supreme Court case that says that. So to the extent that Rule 11 makes a reference to the fact that an appearance by its nature alone will not be deemed a general appearance, it still does not, I guess, clearly answer the question whether this court still recognizes a distinction between special and general appearances. And there is a footnote in the Lamarche case that Justice Lank, I believe, authored, that makes a reference to the fact that the federal courts have abolished it and appears to suggest that it exists here. And then the question would be whether the defendant in this case forfeited that special appearance by its actions here, by filing a answer to Ziabicki's cross-claim that did not include that disclaimer that it was continuing and maintaining its special appearance.
But didn't it incorporate all of the affirmative defenses and prior responsive pleadings?
It did, but while we're in this world of technical distinctions, the question is, did they retain the technical distinction of a special appearance, which they chose to do in their answer by saying, this is a special appearance, and we have an affirmative defense based on personal jurisdiction, which they did not do in their answer to Ziabicki's cross-claim. They did not continue with this special appearance, then incorporating all the affirmative defenses from the answer.
But doesn't it matter that the corporation had a constitutional due process right to not have the case adjudicated in Massachusetts, and that when we evaluate what one must do to waive that constitutional right, it may be a higher threshold than if it were simply the inadequacy of service?
It does not need to be a higher threshold because the due process consideration is completely ameliorated by the existing rules of civil procedure in Massachusetts, including Rule 12. So a defendant who has been aware enough of a personal jurisdiction defense and has chosen to put it in its answer certainly should be held to some reasonable standard of then moving forward with that rejection of the trial court's jurisdiction and doing something to preserve it.
Where does it say in the rules that that's required? It says you can do it either in the responsive pleading or by motion. It doesn't say you must proceed by a Rule 12b2 motion.
And
no case says you must.
the appeals court cases, this gets into a bit of a dispute on what these appeals court cases say, do appear to say that it can be forfeited based on time and conduct. And the
But that's
defendant's
not,
been,
none of them concerned the defense of lack of personal jurisdiction.
Yes, I did.
I believe they
Yes, they
did,
did.
yes. I believe some of them. The defendant argued in its brief that they were all entirely service of process cases, but I believe that that's not the case.
Okay.
and that some did involve personal jurisdiction. And certainly, even the defendant agrees that some of the federal cases.
Yes, but I'm not talking about the federal cases. I'm talking about the state cases.
No,
There are state cases that
Yes.
say you can waive personal jurisdiction when you have raised it in a responsive pleading.
Yes.
The one case where it was raised in a responsive pleading is the, if you'll excuse me a moment, Your Honor. The language of the cases does not speak of it in terms of whether it was raised, but there is a case, Sarin versus Oshner, 48 Mass App Court 421, where indeed the defense was in the answer. And certainly, overall, it is the decision to find forfeiture, as was found by the trial court here, is essentially a decision that there is a point in time where the conduct of a defendant or just delay alone should be grounds for it being unfair to the other parties, including the plaintiff, for there to be a complete rejection of the trial court's jurisdiction.
But the practical consequence of your argument essentially is that you must proceed by motion.
Well, it's true, that is. And the burden on the defendant is minimal in that respect because all they need to do is file a motion, and then the burden shifts to the plaintiff to have to show personal jurisdiction can exist.
Which may be a perfectly sensible rule, but it's not our rule, at least not yet. I mean, how can we basically say you must proceed by motion when Rule 12 says you may proceed by motion or you may simply preserve it in your answer?
But it's a balancing of due process because the plaintiff would argue that, in fact, there is actually a due process deprivation on the part of the plaintiff, who then is subjected to the discovery rules, including a merits-based deposition, an evasion of their private interests. In this case, and this is a major conduct issue here, compelling an inspection of Mr. Cole's residence using the discovery procedures that are really only supposed to be available to litigants in the courts, and instead was being used in this case by the defendant who was going to be rejecting the court's jurisdiction.
But you knew, presumably, that the personal jurisdiction defense was there because counsel says that it was a part of every deposition that was taken.
Could you talk about what was the discovery that went on? I mean, in response to that question.
The discovery that went on in this case did not focus at all, as found by the trial court, on the personal jurisdiction defense. And it would be, at a minimum, mischaracterizing what was taking place in the case to say that,
Well,
that's what
focus and
happened.
involve are two different things, perhaps. But did all the discovery have a component, or
No.
much of the discovery have a component of the personal jurisdiction kinds of facts?
There were multiple discovery activities that had absolutely no relation to personal jurisdiction whatsoever, including a deposition of the individual, James Wright, who restored the painting after it was damaged.
Well, what have other courts done that are in similar situations as us with comparable rules, if there are indeed are any, in trying to decide when the due process lack of personal jurisdiction is forfeited by ongoing litigation without any affirmative attempt to extricate yourself from the litigation in the foreign state? At what point is blowing out of both sides of your mouth, amount to a forfeiture of lack of personal jurisdiction? Have any other courts dealt with this? State courts?
State courts, it's actually the test as framed by the appeals court that we would urge this court to adopt and essentially recognize based on the multiple appeals court cases that, granted in some instances, reference it only in dicta. And that two-part test is looking at whether there's been undue delay in asserting the defense, bringing the defense to the trial court's attention in a motion, or two, whether the defendant's conduct in the course of the case was inconsistent with it. And that's a perfectly fine test, and that's the test that we would urge this court to adopt.
That is essentially, certainly the second part, is essentially what the federal courts have done. Is that right?
Exactly. And the appeals court cases mainly developed that test by looking to the federal court decisions on this that have found and chosen to say, Rule 12, the spirit of Rule 12 is to expedite proceedings. And when the defendants, one of the defendants' defenses is that there's no need to reach the merits of the case, it is, and now I turn to the harm here, which is it is unfair to the plaintiff and frankly the other litigants to give the defendant a license to forum shop, first of all, into whether this forum is going to be a friendly forum to pursue the case, and then two, to probe the plaintiff's case as deeply as it chooses to before getting around to notifying the trial court that it needs to throw out the case on a jurisdictional defense.
Of course, they're the ones who got sued. They didn't bring themselves into court.
But they are also availing themselves of really rules that should only be available to the litigants. And in this case, if we're talking about Mr. Kroll, a citizen of this Commonwealth who's saying, okay, you're going to take my deposition, you're going to invade my personal residence, and you're doing that, and you're saying you yourself are not subject, and you're doing that under the rules promulgated by this court, but you yourself aren't subject to any of those rules. So even if they cooperate in discovery, it's still unfair to the plaintiff to then have them get to bring out this defense at the end of the day.
Think something. Were any of the defendants or their representatives deposed?
The defendant was made available for a deposition, a video deposition. That did happen. And a deposition of the third-party defendant took place in Wisconsin as well.
Do the reporter's notes to the Rules of Civil Procedure suggest that the reason why we allow the lack of personal jurisdiction defense to be included in an answer is essentially to preserve the issue, having to the party who brought it appropriately in a 12B motion and then lost, they then can raise it in the answer and preserve it for appellate review. Is there anything that suggests that that's the reason for the structure of the rules?
I did not find anything in the reporter's notes to that effect. I do think that the cases that have been issued by the SJC on this subject go to that exact point, which is that certainly the plaintiff here does not dispute that if Seuffer had filed a Rule 12 motion and somehow, contrary to what the trial court judge, the plaintiff managed to come up with some evidence to show a stream of commerce possibility for grounding jurisdiction here, that they would have then been free to retain that defense all the way through trial. There's no question that the cases say that. They would have been free to retain that defense. But still, the rule that we are asking the court to adopt here is that the rule as framed by the appeals court at a minimum, if not adopted by the appeals court, and certainly adopted by federal courts, which is that a two-part analysis left to the discretion of the trial judge is appropriate, which would look what type of delay occurred and what type of conduct happened. And before I turn to the delay in conduct in this case, I do want to raise another technical waiver argument that is in the plaintiff's brief, and that technical waiver argument goes to some language which we were unable to find a case interpreting. And the language from Rule 12 that I'm referring to it says, excuse me again, I apologize. I won't read from the rule excessively, but just the sentence in particular is, a motion making any of these defenses shall be made before pleading if a further pleading is permitted. I realize it's tough to read it out of context, but the defendant's spin on that sentence is that that sentence doesn't override the freedom of a defendant to either raise it by motion or include it in a responsive pleading. And the plaintiff disagrees with that, in part because earlier in Rule 12b, it says that these defenses shall be asserted in a responsive pleading, and refers to the word, uses the words responsive pleading. Later, in the Rule 12b, it says, a motion making any of these defenses shall be made before further pleading if a further pleading is permitted. And in this case, a further pleading was permitted. The defendant went ahead and filed more pleadings, and they did not make a special appearance, and this says a motion shall be made before further pleading.
Gloss on that?
Is there any gloss?
Like by the reporter, or any case gloss on that?
I did my best to find any explanation for that sentence that I could. I will say that it is not the same language in the federal rule, partly due to a reworking of the language of the federal rules.
But your view is that that's a reference to a motion to dismiss, I assume? Are you saying it's a
Correct.
reference to motion for summary judgment?
No, it's a motion to dismiss, that a motion to
So this
dismiss.
says that a motion to dismiss shall be made before you do an answer.
Well, the defendant's gloss is that before you do an answer, and certainly that's one way of reading it, but it says further pleading, and that language is different than the language responsive pleading, which we'd say an answer is a responsive pleading. Further pleading was the cross-claim and the answer to that cross-claim. So it says a motion shall be made.
Mr. O'Brien, your time is up.
Thank you, Your Honor.
Thank you. All right, we'll take our morning recess.